Hello and welcome to our presentation on eligible expenses for FSAs, HRAs, and HSAs. My name is Erin Marjorie, and I am an attorney with extensive experience in employee benefits and employment law. I am going to use my legal background to help you gain a better understanding on eligible expenses for FSAs, HRAs, and HSAs. An FSA is a health flexible spending account. There are dependent care FSAs as well, but they are not addressed in this presentation. An HSA is a health savings account. An HRA is a health reimbursement arrangement. These account-based plans differ in several ways, but they all provide tax-free funds to reimburse participants for certain medical expenses, generally using either employee pre-tax dollars or employer contributions. In this presentation, we will review the expenses that may be reimbursed by each type of account. The role of the employer in reimbursing expenses under these plans will depend on which type of plan is offered. An employer that establishes a health FSA or HRA has flexibility in the plan's design regarding the expenses that may be reimbursed. The employer can't go beyond the restrictions dictated by the Internal Revenue Service, but the employer may limit the expenses that can be reimbursed. However, the employer or a plan administrator selected by the employer also has the responsibility of approving only permitted expenses and making sure reimbursements are made in accordance with the plan document. The employer has a more limited role related to HSAs and is not responsible for approving reimbursements. Funds can be distributed at just about any time, and it is the employee's responsibility to make sure that distributions from the HSA are either used for permitted medical expenses or that required taxes are paid. The purpose of all three types of accounts is to pay for unreimbursed medical expenses. To qualify for tax-free reimbursement, expenses must be for medical care, as defined in Internal Revenue Code Section 213D. Medical care is defined as diagnosing, mitigating, treating, or preventing disease, or care related to any structure or function of the body. Expenses must be for items or services that are primarily for preventing or alleviating a physical or mental defect or illness. For certain expenses to be deemed medical care, it must be established that the expense would not have been paid but for the disease or illness. That is, the item is not for medical care if the individual would have paid for it even without a medical condition. Tax-free reimbursement is not available for personal care items that do not meet the definition of medical care, such as vitamins, shampoo, or toothpaste. Items or services that are personal care may benefit an individual's general health, but are not related to a specific physical or mental illness. Items that are for cosmetic purposes only also do not qualify as medical care. However, there is an exception for cosmetic surgery that is related to health or to repair certain injuries and disfigurements. Certain items that would ordinarily be considered personal care items may qualify as medical care if they are used to treat or alleviate a disease or injury and they satisfy the but-for test. The determination of whether a personal care item qualifies as a medical care item will be made on a case-by-case basis. Examples of items that may be considered medical care items are sunscreen, medical grade face masks, skin products, and probiotics. FSAs, HRAs, and HSAs are similar in that they all reimburse medical care expenses on a tax-free basis. However, there are important distinctions between the accounts when it comes to other expenses. Specific rules relate to things like reimbursement of health insurance premiums, long-term care expenses, and expenses of certain family members. Health FSAs may not reimburse premium payments for other health coverage, such as a health plan offered by an employer, COBRA coverage, benefits such as accidental death and dismemberment, and long and short-term disability coverage and Medicare. FSAs are also prohibited from reimbursing qualified long-term care premiums and expenses. HRAs have more flexibility than FSAs with respect to health insurance premiums. HRAs can reimburse accident or health insurance premiums for current employees, retirees, and COBRA qualified beneficiaries, unless the employee has the ability to pay his or her portion of the premium on a pre-tax basis through a cafeteria plan. HRAs that are not also FSAs may reimburse qualified long-term care expenses. However, administering reimbursement of long-term care expenses can be complex, and some employers choose to limit reimbursements for those expenses. In general, HSAs cannot reimburse health insurance premiums, including high-deductible health plan premiums. However, HSAs can reimburse premiums for federal continuation coverage, like COBRA or USERRA coverage, qualified long-term care premiums, even if offered through a cafeteria plan, premiums for health coverage while receiving unemployment benefits, and retiree medical coverage for HSA holders who are age 65 or older. Other limitations apply to expenses reimbursed under these plans. The expense cannot be unreasonably expensive or lavish. If there is a less expensive way to obtain treatment, the excess cost might not be reimbursable. However, the employee is not required to choose the least expensive treatment. In order to be reimbursed for expenses related to over-the-counter medicines and drugs, the individual must have a prescription for the medicine or drug. Double dipping is not allowed. This means that expenses reimbursed by these plans may not also be reimbursed by another plan or deducted on the individual's taxes. There are also a number of restrictions related to the timing of expenses. They must be incurred within the coverage period, not before the plan exists or the individual is eligible to participate. In most cases, advanced reimbursement before the expense is incurred is not permitted, although special rules apply for long-term items such as orthodontia. The individual has to actually receive services, but the bill does not have to be paid before reimbursement can be made. The individuals whose expenses may be reimbursed will differ slightly depending on the type of plan. All three plans may reimburse expenses for the individual and his or her spouse. They may also reimburse expenses of the individual's tax dependents, including a domestic partner that qualifies as a tax dependent. The rules for FSAs and HRAs have been revised to incorporate the healthcare reform requirement that coverage be offered to a participant's adult child through the end of the tax year in which the child turns 27. However, the rules for HSAs have not been changed. So children must meet the prior requirements to be considered a tax dependent for reimbursement purposes. Your broker has additional information on these types of accounts. Please contact your broker for more information on FSAs, HRAs, and HSAs, including more information on expenses eligible for reimbursement. Thank you for viewing this presentation on eligible expenses for FSAs, HRAs, and HSAs.